I've had a lot of fun doing work for poor people as a lawyer. I think from the time I first came to this program, I was very impressed by the tradition that preceded me here of really taking seriously major issues of poor people and going to court about it and doing some good work. I think when I first arrived new to Virginia, there were 3 or 4 cases at various stages of federal court or federal appeal, which resulted in some remarkable progress on both the criminal front, because at that time we were representing people in misdemeanor cases, and the civil front. And not long after I started here, I was part of a litigation effort to correct the problem of costs of publication in divorce. This is one of those things that goes right to the heart of the pressure of people wanting divorces, but as to how you accomplish it when it costs so much, as it used to when you had to pay for newspaper ads. And this was shortly after the wake of Bodie versus Connecticut, a very important United States Supreme Court case about due process in connection with divorces. And Virginia was having a hard time coming to grips with that, and still required publication at more expense than our clients could afford. So we brought after floundering around several times with other alternatives, we brought a civil rights suit against one of our favorite local judges who felt like he had to turn us down in an application to do something about it. And it ended up in the first in a 3-judge court, and then in the Fourth Circuit. And we got a nice decision that it was unconstitutional to this was pretty obvious to us, to charge people fees they couldn't afford as an impediment to divorce. And that was really part of a period in which we seemed to be suing judges all the time. I think at one point I counted we had brought 11 suits against judges, mostly civil rights suits, for various reasons. And the art form was in doing it in such a way that you came away as a friend of the judge instead of having made a hostile enemy forever. So we had developed that to a pretty high level, and it was pretty exciting stuff. But there was a whole lot of other stuff to be done, and some of my fonder memories are of the cases that got to the consumer cases that got to the Virginia Supreme Court. There were several which were useful in establishing the parameters of the Virginia Consumer Protection Act. And we always seem to be getting there a little late to solve the major problem at the time, but we had an interesting case during the period where mortgage lending was running rampant, that brought some usury law to bear upon mortgage lending, and had it been decided a couple of years before, would have prevented a lot of oppression to poor folks. We also had a case in which I participated just on the briefs, in which the Virginia Supreme Court decided that the necessaries doctrine as it existed at the common law was unconstitutional in Virginia, and that was very satisfying. It was the first case that the Virginia Supreme Court had addressed on issues of gender discrimination. So that was a very satisfying thing. We've had a number of issues that we've worked on hard in the form of legislative or administrative lobbying. I think the long-term one of those was several years of effort, starting with our local congressman and then working through the departments of the federal government to try to protect Social Security money in bank accounts. It seems like a ridiculous issue because everybody knows that Social Security money is exempt as a matter of law. But for the better part of 2 decades, it just wasn't that way in practice, because the banks made more money off of giving away people's Social Security than they did off of the deposits they attracted by protecting it. So it took a long time and a lot of lobbying, which we were only peripheral to, but which we participated in sort of a national task force of lawyers trying to articulate what the system ought to look like. And that finally came to pass a couple of years back when the Treasury Department finally imposed a reasonable rule that commanded that banks protect the money like they should have been. There was another occasion some years back when somebody was trying to make improvements in the law having to do with protection of poor debtors and their household essentials. And that was in the age when the list consisted mostly of things like your spinning wheel and your cards for carding wool, and pretty useless stuff from a bygone age. And it just happened that the W&L law professor who was asked to draft some legislation and I were on good terms, and he asked for some help, and we came up with a list of very reasonable practical things that needed to be added to the list, and that sort of sailed through because nobody really had any objection. It's just that nobody had thought about what it should be, and I found some satisfaction in that. There's just no end of issues to address. I think over time what's changed is that it used to be the federal courts that were very open to the needs of people of color, of people of poverty, to use the law to straighten things out. And that's not so much true anymore, but partly because of congressional limitations, partly because of change over time in the judiciary, so that harder than it used to be to bring a case that poses an issue squarely for judicial change. And natural reluctance on the part of judges, particularly state court judges, to make a change like that. And I think that the Virginia judiciary system is inherently conservative because it's so hard to get an appeal of a civil issue into the Virginia Supreme Court that I think circuit judges are rightfully reluctant to make any dramatic changes. But it means the system as a whole is quite conservative, and it's not as easy to succeed as it used to be with dramatic impact litigation. It still can happen, and even the bit by bit litigation that occurs on important issues can have a net impact that's substantial.